Case 2. Northwest Airlines, the plaintiff, versus Minnesota, the defendant. Where are we? We're at the Supreme Court of the United States. That's where this case takes place. Let's start with the facts. Northwest Airlines is a Minnesota corporation, and its principal place of business is in St. Paul. It is a commercial airline carrying persons, property, and mail on regular fixed routes with due allowance for weather, predominantly within the territory comprising Illinois, Minnesota, North Dakota, Montana, Oregon, Wisconsin, and Washington. For all the planes, St. Paul is the home port, registered with the Civil Aeronautics Authority, under whose certificate of convenience and necessity Northwest operates. At 6 of its scheduled cities, Northwest operates maintenance bases, but the work of rebuilding and overhauling the planes is done in St. Paul. Details as to stopovers, other runs, the location of flying crew bases, and of the usual facilities for aircraft have no bearing on our problem. The issue. This case was one of first impression concerning the constitutional limitations, if any, upon state power to tax airplanes. More specifically, should the concept of tax apportionment, traditionally applied to other land-based modes of transportation, be applied to a fleet of airplanes? Note, a case of first impression is a new legal issue or interpretation that is brought before a court. In a case of first impression, the exact issue before the court has not been addressed by that court or within that court's jurisdiction. Thus, there is no binding authority on that matter. The holding. The court held that a general Minnesota personal property tax applied to all personal property within the state and without discrimination applied on the corporation's entire fleet of airplanes, did not violate the Commerce Clause nor the Due Process Clause of the 14th Amendment of the U.S. Constitution. And now the reasoning behind all this madness. Let's first discuss what Minnesota was seeking to tax. Minnesota was taxing all airline property, including its airplane fleet, within the state during the tax year of 1939, and that was not protected from taxation by any other state. All of the airplanes were continuously engaged in flying from other states, except when laid up for repairs and overhauling for unidentified periods. On May 1st, 1939, the time fixed by Minnesota for assessing personal property subject to its tax, Northwest's scheduled route mileage in Minnesota was 14% of its total scheduled route mileage, and the scheduled plane mileage was 16% of that scheduled. The airline based its personal property tax return for 1939 on the number of planes in Minnesota on May 1st. But the Minnesota Taxing Authority assessed a tax against Northwest on the basis of the entire fleet coming into Minnesota. The lawsuit was based on this additional assessment. The Supreme Court of Minnesota, with 3 judges dissenting, affirmed the judgment of a lower court in favor of the state, finding the tax valid. Let's look at what factors make Minnesota a unique taxing authority relative to the taxing power of every other state in which Northwest Airlines operates. The court itemized a number of benefits that the airline gains as a function of doing business in Minnesota to explain why Minnesota in turn had a unique taxing authority. Specifically, the relation between Northwest and Minnesota, a relation existing between no other state and Northwest, and the benefits which this relation affords are the constitutional foundation for the taxing power which Minnesota has asserted. Other factors cited by the court, the benefits given to Northwest by Minnesota and for which Minnesota taxes, its corporate facilities, and the governmental resources which Northwest enjoys in the conduct of its business in Minnesota, are concretely symbolized by the fact that Minnesota's principal place of business is in St. Paul, and that St. Paul is the home port of all its planes. No other state can claim to tax as the state of the legal domicile, as well as the home state of the fleet, as a business fact. No other state is the state which gives Northwest the power to be, as well as the power to function as Northwest functions in Minnesota. No other state could impose a tax that derives from the significant legal relation of creator and creature and the practical consequences of that relation in this case. On the basis of rights, which Minnesota alone originated and Minnesota continues to safeguard, she alone can tax the personalty which is permanently attributable to Minnesota and to no other state. Lastly, it has been customary to tax operating airplanes at their overhaul base. Some of Northwest Airlines airplanes are in Minnesota for only a portion of the tax year. So the court looked at whether these airplanes are therefore exempted from Minnesota state tax, and also whether tax should be apportioned based on the amount of time an airplane is physically located in Minnesota. The airplanes did not acquire a permanent or continuous location outside of Minnesota. The court rejected the idea that Minnesota's taxing authority is less because it already taxes the cost of transportation. Rather, a corporation is taxed for all its property within the state during the tax year, none of which was continuously without the state during the whole tax year. This constitutional basis for what Minnesota did reflected practicalities in the relations between the states and air transportation. In other words, the domiciliary state has total taxing power over any aircraft that, 1, was within the state during the tax year, and 2, was not outside the state continuously. In addition, the court rejected the idea that tax apportionment had application in the airplane age. The court gives the example of a non-domiciliary state taxing an interstate railroad or telegraph company. But the court regarded this principle as applicable to old means of transportation and communication, such as express companies and telegraph systems. As such, the court rejected a fractional approach to taxation to airplanes. That is, the doctrine of apportionment has neither in theory nor in practice been applied to tax units of interstate commerce visiting for fractional periods of the taxing year. The continuous protection by a state, other than the domiciliary state, that is, protection throughout the tax year, has furnished the constitutional basis for tax apportionment in these interstate commerce situations, and it is on that basis that the tax laws have been framed and administered. The court continued, although a part of the taxing systems of this country, the rule of apportionment is beset with friction, waste, and difficulties, but at all events it grew out of and has established itself in regard to land commerce. To what extent it should be carried over to the totally new problems presented by the very different modes of transportation and communication that the airplane and the radio have already introduced, let alone the still more subtle and complicated technological facilities that are on the horizon, raises questions that we ought not to anticipate. Certainly we ought not to embarrass the future by judicial answers which at best can deal only in a truncated way with problems sufficiently difficult even for legislative statesmanship. As we conclude, let's look at the concern Justice Black raised in his concurrence. Justice Black noted that the case illustrates the difficulties arising from state taxation which bears an incidence upon interstate commerce. These problems, it seems to me, call for congressional investigation, consideration, and action. The Constitution gives that branch of government the power to regulate commerce among the states, and until it acts, I think we should enter the field with extreme caution. In other words, Congress is better situated than the court to make this decision.